I'm set for oral argument in Lattin versus Shamrock, our case number CV190761. Good morning, counsel. Each side has 20 minutes to present oral argument today. Ms. Foster, if you wish to reserve a portion of that time for your rebuttal, you're free to do so, but you need to keep track of your own time. In a different world, you'd have a clock right in front of you at the podium. We're not in that world, so I'm keeping time sort of informally on a separate device, and I'll let you know kind of where you are when you're done with your initial argument. And if you hit that 20-minute mark, we have reviewed the case, we've conferenced it, we're familiar with the record. We'd encourage you to keep that in mind as you present oral argument today. We are recording the proceedings and it will be posted in due course. So please, as you begin your presentation, let us know your name and who you represent. And with that, Ms. Foster, you may proceed.
Good morning. Thank you. Yes, my name is Teresa Foster and I represent the appellate, Christy Lattin. This case involves Lattin's interest in a company known as Shamrock Materials, LLC. Initially, when this company was formed, there was 3 equal members. They were all members, but subsequently, Lattin's membership interest was converted to a profit participation interest. And a copy of that PPA is attached as Appendix C to our opening brief. In that profit participation agreement, it clearly provided that Lattin was a profit participant, and during 10 years, she had the option to convert that to a membership interest in return for her prior services and payment of $1. The profit participation agreement did not require Lattin to make any capital contributions. The operating agreement would have required capital contributions, but as a result of the trial court's order back in January of 2018, the court ruled that Lattin was not a member. She was not.
Ms. Foster, let me ask you a question. This is Judge Weinswag. On the capital contribution point, would you concede that your client ultimately exercised that membership option or equity option? I guess let's start there. Would you concede that?
Yes, I would, Your Honor.
Okay, and would you also concede that there is there will be, I guess, capital contributions if there haven't already been since that date that will require your client to contribute to the company?
In the future, there would be, correct, Your Honor.
Okay, and so at this point, how much of the capital contribution was paid before it had to be paid?
162,000.
Was it?
162, Your Honor.
Okay, and so how is your client damaged? Other than, I guess, maybe money can be working for you and you could be gaining profit in other endeavors. I suppose that might be your argument, but otherwise, how is your client damaged, given that she will be, whether it's in short order or otherwise, responsible for 100 and whatever you said in capital contributions?
Actually, Your Honor, with regards to the prior contributions, she would never have been responsible for those. Under the profit participation agreement, she had the right to get that percentage interest without putting any money in. And the way that she...
Yeah, and I understand, and I don't contest that, but that before she was a member, she had no requirement to contribute, but she is a member, and she will have, if you read your colleague's brief, she will have contributions in short order, and so what are the damages given that?
Well, I think the appellee in their response brief at page 47 explained what the damages are. The benefit that she receives is that she might get her money back if the company were to liquidate. She had no obligation to make it, but under their scenario, the only way that she gets a benefit from that capital contribution is down the road If the company liquidates during her lifetime, and if it has the money, then it can return her capital contribution. There's no reason for $162,000 to sit there in the company until some future date that it might liquidate when she had no obligation to make that. In the future, if both parties make capital contributions, that's a different issue. There have not been any capital calls since she exercised her membership interest.
Okay, so that's what I'm talking about, not the liquidation, because it seems to me the argument is more that your client is a member and will have capital contributions, and it's sort of put in the bank. Your colleague, your adversary, has conceded and said we will hold this money, and it's almost a credit as we move forward, and you do have capital contributions that you must meet.
Well, Your Honor, I've never seen anybody concede or argue in this lawsuit or in the appellate brief that it's going to be a credit towards future capital contributions. No one has stated that. In other words, if there's a capital call and Ms. Lattin has to put in $50,000, are you saying you think there's something in the record that she would get a credit on her earlier 162 that she doesn't have to put in more?
And I'll certainly hear from your colleague, but I remember, I mean, I thought that was the point on damages, which is your client, yes, at one point was not a member, and yes, had no requirement to answer capital contributions, but is a member now and will have to answer capital contributions, and thus this 160 can be used to meet those.
I have not seen that, your argument, and the way I reviewed the appellate briefs, I believe that the appellee has capitalized on what the trial court judge said in its minute entry issued on April 2 of 2019. The judge determined that the claim was futile and said, plaintiff contributed capital to the LLC, which is now booked as a capital contribution. The proposed claim would be futile. That is the problem, is that it's booked as a capital contribution. She's entitled to that membership, and she's entitled to be in whatever percentage as a member without making any contribution. The proposal that she would get a credit in the future has never been provided.
Well, as a member, she has to answer capital calls.
Future capital calls.
Right. And so are you saying that just doesn't happen? There hasn't been a capital call? And I mean, what I was saying is, I suppose you could say I could be invested in Microsoft in the interim or some other endeavor. And so my damage will be that margin of how I could be using my money in the interim until there is that capital call. But you don't seem to be, are you saying that's irrelevant, her obligations as they now stand?
It's irrelevant and it's premature. There have not been any capital calls, and she has not been offered a credit for that $162,000. We're looking at contributions she made beginning back in 2005. She could have used that money for a lot of purposes over the last 16 years. The loss of the use of that money, she could have spent it if she wanted to have fun with it. She could have invested it. She could have done something else with it. But it's been sitting there, and it's a contribution that to date she has not been obligated to make. It would be different if they would have come back and said, okay, we're requiring a capital contribution of $162,000, and we're going to give you credit for what you did in the past, but that did not occur.
Okay, so go ahead, counsel. Sorry to bother you. I just wanted to get that point down.
No, I appreciate you asking about that. The trial judge found two issues with regards to futility. One was that it had been booked properly as a capital contribution, but the fallacy in that argument is that she had no obligation. Her membership was based on prior services and $1, and she received those prior services. She provided those prior services, and she paid that $1. The trial judge's other issue with regards to futility was there is no dispute that the plaintiff, Shamrock, and Gignac are parties to a written contract governing their relationship, the PPA, and that alone makes the unjust enrichment claim futile. The problem is the PPA did not require any capital contributions. The operating agreement may have, but as a result of the trial court's ruling, Ms. Lattin was not a member and was not obligated to make those contributions under the operating agreement. So I believe the trial judge was wrong both times that he said that the claims would be futile. And more importantly, the trial judge never even looked to whether or not there was any prejudice to the appellee. The appellee's argument in the responsive brief is that discovery would have been required to find out why Lattin made these contributions. No discovery is required. The CPA, Terry Branch, testified in her deposition when the company needed money, every time she would call plaintiff or her husband and she would ask them to make a capital contribution. The CPA herself referred to these as capital contributions. The appellee's responsive brief indicates that Lattin voluntarily made some contributions, but that's not what the evidence showed. The CPA asked for those contributions. I'd like to save some time for my rebuttal, so I'd like to also briefly address another issue raised in our opening brief, and that is about the Lattin's percentage interest, and that's the 33% versus the 50%. With regards to the original PPA, I think it was clear. There was 3 members. They were each going to get 1/3 interest, and under the PPA, Lattin was entitled to a 1/3 profit participation interest, and she could convert it to an equal 1/3 membership interest. The problem is when McCann removed herself as a member, her contributions went back to the company, her membership interest went back to the company, and the parties executed a short 2-page amendment that didn't even address the option agreement. It addressed her PPA being reduced or increased from 33 to 30% to 50%, but it did not do anything with regards to the option. McCann and Lattin both alleged in their declarations that they believe she was entitled to an equal interest.
Counsel, let me ask you though, because you're right, it didn't change the option, but isn't that telling? And what parties subjectively may have believed is interesting, but isn't it the express terms of the written document that govern?
If we were just dealing with the original agreement, Your Honor, I would agree with you. The problem was that the circumstances changed and the parties executed an amendment, and that changed the terms. And
I agree, but I didn't change that term. It didn't change the 1/3 owner membership interest term. It left that unchanged.
And that's the issue. It did not say that the option agreement shall remain that she's only entitled to 1/3, because that's not what the parties intended.
Well, I know it didn't say it changed it, but and it also didn't say that it remains the same. But if it didn't change it, it remains the same, doesn't it?
And didn't it say, counsel, that it does remain the same? Let me read you the exact language. The terms and provisions of the, and then here I sort of have bracketed option agreement shall continue in full force. Is that what the amendment says?
And with regards to the terms of the option on exercising it, those did remain in full force. She had 10 years. She was required to give them written notice, and she was required to pay the $1. But the issue is the parties, when they originally did this PPA, they believed that they were all going to be equal members. And after the PPA was amended, Lattin and McCann testified or submitted declarations that they still believed that they should be equal members. And the trial court did not consider that in light of Taylor because the judge believed that it contradicted the documents. But it did contradict the documents.
So you're sort of picking and choosing what terms of the agreement shall continue in full force when the amendment says the terms and provisions, without that sort of defining or limiting factor, quote, shall continue in full force.
If you look at the option provision, that's a discussion about how she's going to exercise the option. She has during that 10 years. Actually, if you know, I'd like to save some time for rebuttal, and I hate to cut you off, but if you want me to address it, I will. I don't want to run out of time for my rebuttal.
Thank you.
Thank you.
Thank you, counsel. And just I'm looking at my stopwatch here. You have about 5 minutes and 20 seconds left for rebuttal. Mr. Van Zanen.
Thank you, Your Honors. I will I'll start right where we left off. Your Honor, that is accurate. The amendment changes one thing and only one thing. It changes the profit percentage interest when non-party McCann left. And it expressly leaves, and it says that all other terms of the profit participation agreement remain in force and effect. It changed nothing else. So it's almost not even correct to say that it just left it alone. It actually affirmed that that those terms were to stay in place. And I think it's also important to note here, and Judge Mullins put this in her minute entry, that this is sort of a feigned mistake. She's saying, boy, I thought all along, and everyone thought all along, that I was actually going to have a 50% conversion interest when I decided to exercise the option. Well, the evidence that Judge Mullins caught, that we presented to her, was that when she submitted her letter to exercise her option, she said, here I am, I'm exercising my option to become a 1/3 member. It wasn't until after a dispute arose, and indeed the attorneys representing the parties, we negotiated probably for a year before there was a suit filed. It wasn't until appellant got counsel and this creative legal argument came up, oh, well, wait, when your profit participation interest changed, let's argue that you were entitled to convert to a 50% member. Her own document exercising the option said, I'm here to convert to 1/3. That casts great doubt that all along she was confused by this amendment.
Counsel,
So
let me ask you to address a somewhat different issue that Ms. Lattin has contributed $162,000 that the entity now holds for reasons that she is saying were misunderstandings under the contracts, that she had no obligation to do that, but she no longer has that $162,000. Please address that issue if you would.
yes, Your Honor. So after the women formed the company, within a month, appellant said, I don't want to be a member. I want to be a profit participant. So as you know, we had two agreements. Now my client, non-party, McCann, were the 50% owner of the company, and there were 3 profit participants. As time went on, McCann left. My clients, this was a struggling company. We laid this all out in the brief. It couldn't pay for employees, couldn't pay for anything. And so my clients were pumping tons of money into this company. And there were times when they went to appellant and said, listen, this is getting expensive. We might throw in the towel. Can you put in some money to help us? And there were discrete items that she helped on, and she's, over the course of this litigation, continues to misrepresent. She put in 1/3 or 50% of all expenses. So there were times we said, this is getting overbearing. Someday you're going to become a 1/3 member for only $1. Can you help us keep this company afloat? So she had no obligation to put in that money, but the trial court found you chose to do that. And there was a benefit to her. If this company could get back past its formative years, she came to own 1/3 of the company for $1. And indeed, my clients pumped in $750,000. She paid $1 and got all of the benefit of my client's $750,000. So she chose.
But counsel, isn't that benefit gratuitous or illusory? I'm not sure. I mean, if she could have gotten in for $1 and she didn't have to pay the 100,000+, what is I think we're calling it now an enrichment. What is the enrichment? Are you saying it would have failed and then she would have lost her $1? Or I mean, I'm not sure what the argument is here.
Yes, that's exactly my argument, Your Honor, is that my clients is the sole member, they could have thrown in the towel at any time. But they said, if we want to get this company past its formative years, we'd like you to help us. And she saw the benefit to helping. She didn't have to, but to help that company survive its formative years. If we can do that, she gets in later for $1. So she chose to do it. She didn't have to do it. And, there's some discussion about how this was accounted for. And this was all admitted at the trial court. Even appellant said these weren't loans. Well, okay, so the CPA is saying, well, you're not formally a member, so I can't book it as equity, but they're not loans. So sometimes they were loans, sometimes they were equity. They were always there. But as the trial court found, once she exercised her option to become a member, she now has her $162,000 capital account, just like my client has a $775,000 capital account for all of the money that it put into the company.
But your client has been at the table the entire 10 or 12 years, though, right? And Ms. Lattin has not, as a member. What was she told? Hey, you don't have to do these, and these are in essence gifts. And if you want to give the company $162,000 for the possibility of exercising an option later, that's how it will work.
She was never told they were gifts. And they're not gratuitous. She got something. She got a greater likelihood that the company would get past its formative years and her $1 option would not be worthless. If the company shut down, she has nothing. But if she could, so the issue was, do we call these loans to the company that'll be paid back someday, or do we book them as equity? And once she exercised her option, she now has a capital account.
And that the exercise of the option is reflects that this goes to the capital account, or was that not addressed in the exercise?
No, she merely says, I'm exercising for $1. I'd now like to be a member, at which point the CPA says, oh, now we know how to book the contributions you made, because we didn't know whether we book them as loans that the company owes you or as capital, because we're waiting to find out if you exercise within 10 years. As soon as she said, I'm now a member, he can say, now you got a capital account. We know how to book these.
So let me ask you, counsel, let's say tomorrow your client issues a capital call. And I think we all would concede that the plaintiff or appellant here must meet a capital call. Is it your position that Ms. Lattin would have to come up with that additional money for the new capital call of tomorrow? Or are you saying she has a capital account and we will sort of draw from that account as we move forward?
Your Honor, no. If there was a $100,000 capital call, my clients would have to put in $666,000. She'd have to put in $33,333. Capital accounts are based on what's currently been put in, and then going forward, you add to that.
And so your position is that this money was sort of came from her as for operating funds, and only when and was treated accordingly somehow, and perhaps inconsistently, and only when she exercised did it go to the capital account. But now that's a paid-in amount. She gets no credit for it. It wouldn't offset future capital accounts, and she couldn't demand its return today.
Well, yes, Your Honor. We couldn't demand our money either. The operating agreement precludes that. Many operating agreements do.
And I understand that, but those funds were contributed pursuant to the operating agreement, as opposed to this other sort of uncharacterizable reason, right?
Well, respectfully, Your Honor, I don't think it's uncharacterizable. My clients went to her and said, if we want this company to survive so that someday it's worth something when you exercise your option, we need help, or else we're throwing in the towel and there will be no company anymore.
What's the evidence of that? What's the evidence of that discussion, dialogue, agreement? Was it just a phone call? We're going to fail unless you give us money you don't need to give us?
Your Honor, I mean, I would have to go back to the Terry Branch deposition, but that was always the answer, or the point was that we have to pay for all the vehicle license taxes for our trucks. It's a lot of money to come out of pocket. Can you help us on this one? And so she would put in a
written agreement to that effect.
No, and that was part of the problem with how to book it. Do we call these loans, or do we call it equity? Because someday she's going to be a member and could have equity. So they sort of these loans or contributions bounced around on the books between debt and equity. once
Well,
she
and I'm not focused on that distinction. What your argument is that Ms. Lattin cannot get her capital contributions back, even though she paid them when she did not have to. And now, looking back, sort of backfilling a rationale. Well, we required that because, I don't know, fill in the blank. We were going to fail. She agreed, right? I mean, I'm fine if you can show me an agreement that says, yeah, she agreed to pay the one, whatever, 100,000, 160,000, even though she didn't have to. But if that's not in the record, I'm not sure that's terribly persuasive.
Your Honor, I think there are two important points to take away from this. Is that one, she received consideration for putting that money in. She got a company that made it past its formative years that was going to be worth something in 10 years. She got something out of that. And again, as the trial court found, when these people came to her and said, we could use some help, she could have said no. But she didn't, because she saw some benefit to paying that money, to helping that company survive, while my clients did everything else, paid employee bonuses out of pocket, bought trucks, once in a while came to her and said, hey, it might be worth it to help us, because one day you'll have a functioning company when you exercise the option.
Well, but option, those two words, when you exercise and the word option, aren't the same. Right? Option is an option. She had not exercised it, and who knows? Maybe, unless she guaranteed that she was going to, and there was some sort of agreement to that effect, but she had not, and she was not responsible for that capital contribution, and so I guess, isn't that the point? Isn't the turning point the moment she exercises that option?
Your Honor, there's no evidence in the record, there never has been, that she was threatened with dilution or a lawsuit. People went to her and said, can you help us out on this one? And that's not gratuitous. There is a benefit. She knows that if I help out and we get this company past its formative years, my option will someday be meaningful. If the company fails because the appellees can't continue footing the bill every time, my option is worthless one day. There will be no company. So she got something out of it. It wasn't gratuitous. She wasn't forced to do it. She could have said no, but she didn't, because she saw value to helping.
Counsel, let me ask you a hypothetical, right? Because it's what didn't happen here, okay? We've talked about the $162,000 that Ms. Lattin contributed before she exercised her option. What if she never exercised her option? The 10-year option expires given the passage of time. She then files a claim for unjust enrichment or its equivalent for return of the $162,000. Isn't that a viable claim at that point?
It may be, Your Honor. I suspect once the 10-year option expired, the parties in the CPA would say, well, then we have to book it as a debt at this point. So it's a loan to the company. And that was always the problem. Do we book this as a loan or do we book it as equity? There's only two ways you could do it. If you're not a member, the IRS cares about that. You can't have a capital account. So we couldn't put it in equity, but everyone said, well, it's not a loan though. So it just kind of bounced around on the books. When the option expired, I feel certain that everyone would say, well, now we need to book it as a loan, and it's a loan to the company. She's a creditor. It needs to be paid back.
And let me ask, and I appreciate that answer, but how does that fact, if she really was paying the 162 to remain in the game to see if she could exercise the option, why should that be treated differently if the option expires on its own terms without being exercised?
Well, because at that point, there would be no possibility of booking it as equity because she will never be a member. So there's only one other option, debt.
from an accounting perspective, I understand that. And what I'm looking at though is from an unjust enrichment claim, you know, under the law, which is a different sort of calculus.
I think I think the answer is the same as what the trial court said, that there's not an unjust enrichment here because you became a member, you have your capital account, you have every rights. She has the same rights with the $162,000 capital account, the same rights that we have with the $775,000 capital account. There's not an unjust enrichment. She is now a member, has a capital account, and all the rights that go along with it. May move on to another issue?
You may.
Okay. All right. I'll touch briefly on the motion to amend regarding Sky Harbor. I think the briefing by appellant here is clear. When she brought this to the trial court, she said, new case came out yesterday, Sky Harbor, and it holds that members owe duties to other members. And as the trial court said, no, it doesn't say that. It says members owe duties in certain circumstances to the company, not to other members. Well, when appellant filed her brief here, she just simply took out to the other members and continued arguing the same point. Sky Harbor is completely irrelevant here because it says nothing about what duties the appellees owed to the appellant. There is a second problem with the argument is that even if Sky Harbor did say their duties owed to other members, appellant was never a member during the time relevant to her proposed amendment. She was only a profit participant, and she even says on page 5 of her reply brief, when she kind of complains that we spent 5 pages on that, she says, the trial court said I wasn't a member, and I'm not appealing that. So the point is, even to take advantage of her misreading of Sky Harbor, she'd have to be a member, but she was never a member, and she's not appealing the court's ruling that she was not a member. The final point on that is that even if fiduciary duties were owed, I found no case that says a fiduciary owes a duty to its beneficiary to check in now and again to see if they've stopped believing what is obvious and remind them what is obvious, which is that when she chose not to be a member, that really meant that she was not a member. And that's what she's saying, if there are duties under Sky Harbor, that's the fiduciary obligation. The third issue on the is really the $62,000. I think the other point is that the court did not abuse its discretion. This was in the court's own words, this was extraordinarily untimely. Even following her logic, she says, I didn't know I wasn't a member until March of 2018 when the court ruled I wasn't a member. Well, that's implausible. She knew all along she wasn't a member because she chose not to be a member. But as the court said, plaintiff's delay in bringing the unjust enrichment claim is extraordinary. Plaintiff filed the action in August 2017, but only requested leave to amend to add this claim in June of 2019. On the eve of trial, even under plaintiff's theory, she knew this claim by March 30, 2018. This undue delay, particularly considering the status of the case, also warrants denying the motion to amend. So the claim accrued years ago at the latest March of 2018, and she waited till the day of or the day before our pretrial conference with trial 3 days away.
Do you have any authority, counsel, for that argument that you have an enrichment if there's a possibility that as a going concern, the business will fail? And so, yes, you paid it when it wasn't due, but we weren't doing well. And so do you have a case that says in that situation, making a capital contribution when you don't have to is not an enrichment?
Your Honor, I don't have a case cite off the top of my head. I just feel that it can be gleaned from the facts. There was a benefit to helping the company, whether it was a loan or a capital contribution or whatever it's called. She got something. She reduced the likelihood that the company would fail and that one day her option would be worthless. She could have relied totally on my clients to continue footing the bill and pumping money into the company, but they could have just said, well, forget it, I'm done. And now your option's worth nothing. or you can help out. So I think from the facts themselves, we can glean that it wasn't gratuitous. She received something. So I'll wrap up by saying that, you know, the fact of the matter is that Appelli caused our clients to spend tens of thousands of dollars on this case, while she hardly participated in trying to prove these allegations that my clients abused Shamrock financially so that it never earned a profit. She never had those facts. She never tried to develop those facts. She never produced an expert report after shutting down questioning and deposition, saying, I can't answer those, my expert will in his report. So while she neglected her case, we had to defend ourselves, including producing an expert report. As trial approached, she'd hardly participate in trial preparation. And I'm bringing this up because I think it's important to the dilatory motive and undue delay. As trial
Counsel, I'll ask you to wrap up. Your time has expired, but I'll give you a few more sentences if you wish.
I'll end with that, Your Honor. Both motions weren't timely, they were futile, and they could have been asserted long before. So just on timeliness, 3 weeks before trial and during a flurry of work and trial preparation that she wouldn't help participate in, and we had to get the court's involvement, then she moves to amend the complaint. The court did not abuse its discretion. Thank you.
Thank you, counsel. Ms. Foster, 5:40 for rebuttal.
Thank you, Your Honor. I'm setting my timer so I won't forget. A really important question was raised a few moments ago, and that was, what is the evidence that the appellees have about the arguments they make throughout their brief that Lattin offered to help, that it was voluntarily, that she could have said no? And the issue is there is no evidence to that effect. The most relevant piece of evidence is Terry Branch's deposition, and it's Appendix F to the opening brief. And it's just one page that I want to focus on. It's on page 101. Ms. Branch has asked some questions, and one question is, when he, referring to her attorney, asked if they were all capital calls, he asked if they were all capital calls. She responds, yes. And the question is, were they all capital calls? And she responds, that's what I assumed they were, yes. And she goes on to state, when she's asked whether or not, when you made the capital calls to either Christy Lattin or her husband Bob, did you have any discussions with them about not being a member and not needing to respond to capital calls? And her response is, no, I never had that discussion. So all we have in the evidence is Christy Lattin's declaration and her sworn complaint that capital calls were made to her and that she responded over 13 times and contributed $162,000. And then we have Terry Branch's deposition that says she asked for capital calls, she would call Christy or her husband, and that they would respond. And she never thought about the issue about the membership, and she never said anything to Christy or Bob about the membership. So we're back to where we started with, is that capital calls were being made by a profit participant who was not yet a member because she had not exercised that membership. A question was asked whether it would have made a difference if she would have not exercised her option. And there is information in the record about that. When the 10 years was approaching, the LLC asked Lattin to basically terminate her profit participation agreement and terminate her right to exercise that option. Unfortunately, because it was 10 years later and a couple moves of houses later, Ms. Lattin did not have any of the documents available. She exercised her option. She looked at the documents that the LLC provided her. She believed it was a 1/3 interest. And basically, she exercised that option in order to save her $162,000. She had made those capital contributions and unfortunately didn't know what had happened or what had been done. She wasn't receiving financial information from the company. The company actually refused to accept the option that she exercised. When Ms. Lattin exercised her option, she believed at that time that it was a formality. She believed from day one, and that's why she brought this litigation, that she was a member. Looking at the profit participation agreement and the original trial judge's ruling, under that agreement, even though there's a section that says division of profits and losses, the section itself, that's only the heading to it, does not provide for division of losses. So I believe that the judge was correct. She was not a member at the time of the profit participation agreement until she actually exercised that option. And unfortunately, it's not just Lattin that believed that she was a member and had an obligation to make capital contributions. It was the LLC itself, through its CPA, who would contact Lattin and ask for those capital contributions. So apparently during this time frame, prior to litigation, the LLC was also treating Lattin as a member. It wasn't until after the trial judge's ruling that she was not a member and was not entitled to deduct losses that Lattin realized she really had no obligation to make those contributions. And in May of 2019, when the trial judge granted the additional motion for summary judgment with regards to damages, basically said that the majority member and manager under the business judgment rule had the right to determine what expenses to pass through that company. Lattin realized she's got $162,000 that's sitting there captive. She will never be able to receive that money. It will never be returned to her, and she had no obligation to make that payment. And that's why the motion to amend was filed. And under Rule 15, you even have the right to file that motion to amend during trial. This was filed shortly before trial. And I believe that the judge was wrong with regards to the futility because the PPA did not govern capital contributions. So there's no issue about a contract governing this obligation. And also the judge was wrong because she has not received any benefit by the $163,000 being placed in her capital account. This goes back to 2005, and this company may never be dissolved during her lifetime. And even if it is dissolved, it may not have the money to pay her back. But more importantly, there is a time value of money. She had no obligation to make those contributions, and so they should have been returned. And quite frankly, I believe this court should reverse the trial court and remand this matter to go back for it to be tried on the merits under unjust enrichment claim. Do you have any questions?
Let me look to my colleagues. No.
Oh, my timer just went off.
Well, good timing, counsel. Counsel, we appreciate your briefing. We appreciate your argument today. You've given us much to think about. We will take the matter under advisement and we'll issue a written ruling in due course. With that, court stands adjourned. Thank you very much.
Thank you.
Thank you.